are the intent to go armed clause of our TCA Code 3917-1307A1 and Article 1, Section 26 of the Tennessee Constitution unconstitutional. Let's look at the facts and dive in. From the case Moorfield v. State, Supreme Court of Tennessee, 1880. The case arose from a situation where a person came before his fellows saying he had been fighting with the bear. The neighbors, responding to the trouble, gathered the firearms that were available and went to hunt the animal. Moorfield borrowed a pistol and joined the group in pursuit. Returning from the venture, he was spied carrying the handgun, reported as such, and arrested for violating the intent to go armed statute that is still on our books today. Going through the lower courts, he was convicted of breaking the law. Appealing to the highest court of the state, he was finally exonerated, his conviction reversed. It is instructive to the people today to understand what the court used to render its verdict. Quoting from the actual transcript, or for the purpose of being armed, in the sense of the statute, is clearly negatived, and the motive was an innocent one. The object of the statute, as we have before said, is to prevent carrying a pistol with a view of being armed and ready for offense or defense in case of conflict with the citizen. That being the specific definition of the intent to go armed in 1880 by our highest court, we find it reversed in 2008 via the District of Columbia et al. V. Heller definition of what the Second Amendment really protects. Quote, at the time of the founding, as now, to bear meant to carry. When used with arms, however, the term has a meaning that refers to carrying for a particular purpose, confrontation. Quoting Justice Ginsburg and Heller from Muscalero v. United States in 1998, in the course of analyzing the meaning of carry as a firearm in a federal criminal statute, Justice Ginsburg wrote, quote, surely a most familiar meaning is, as the Constitution's Second Amendment indicates, wear, bear, or carry, upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive or defensive action in case of conflict with another person. Scalia said of that quote in Heller, quote, we think that Justice Ginsburg accurately captured the natural meaning of bear arms. Although the phrase implies that the carrying of the weapon is for the purpose of defensive or offensive action, it in no way connotes participation in a structured military organization. Regarding the restrictions placed on the people by our General Assembly in 1801, 1821, and 1870, making it a crime for a citizen to carry a firearm with the intent to go armed, they are clearly unconstitutional and have been set aside by this later court. It is my further belief that the finding of the McDonald v. City of Chicago case in 2010, where the Supreme Court incorporated the Second Amendment against the states, invokes Article 6, Section 2, the supremacy clause of our federal Constitution. It renders the current Article 1, Section 26 of the Tennessee Constitution moot, as the Second Amendment is supreme, the laws of Tennessee notwithstanding. Remember the original construct of our Second Amendment analog from 1796, quote, that the free men of this state have a right to keep and to bear arms for their common defense, close quote. The most recent Supreme Court case, Bruen, now dictates, quote, the government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearms regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. The Jim Crow charge and change to our Second Amendment analog from 1870 gives power to the General Assembly that it simply does not have. It must be changed to satisfy the requirements set forth in Bruen when it says, quote, after all, the Second Amendment guarantees an individual right to possess and carry weapons in case of confrontation, and confrontation can surely take place outside the home, close quote. Our state legislators have the delegated power from us to set punishment for criminal acts It is their job to listen to the people who are to instruct them and to make laws which provide protection for the people within the confines of the Constitution. Their oath requires that each, in all appointments, to vote without favor, affection, partiality, or prejudice, and that they will not propose or assent to any bill, vote, or resolution which shall appear to them injurious to the people, or consent to any act or thing whatever that shall have a tendency to lessen or abridge their rights and privileges as declared by the Constitution of this state. These same legislators do not have the power to deny constitutional rights, however good their feelings might be. Article 11, Section 16 of our state constitution says, "The Declaration of Rights hereto prefixed is declared to be a part of the Constitution of the state, and shall never be violated on any pretense whatever. And to guard against transgression of the high powers that we have delegated, we declare that everything in the Bill of Rights contained is accepted out of the general powers of government and shall forever remain inviolate." Let your elected employees know you understand what that means, that they have no power to deny rights that we received from our Creator. And finally, from Thomas Jefferson, those who expect to be both ignorant and free expect what never was and never will be. If you learned something today that was beneficial, hit the like and subscribe button. It helps to get our message out and sell the brand. Check back for more content as often as you can. You can find our website at www.tennesseefirearms.com. If you are new there, click the subscribe button on that page as well to receive free email updates about issues that affect your Second Amendment rights in Tennessee.